Good evening. It's now 6 o'clock. I'm handing over to Dr. William Westhuizen. Thank you, William.
Thanks so much, Ronel. Good evening, everyone, and thanks so much for joining us for the third in our medico-legal webinar series hosted by the Health Policy Law and Ethics Committee of SALRC. We've got a wonderful webinar for you once again tonight. We've got Ms. Ronel van Zyl, who is a senior state law advisor and also the researcher that has been assigned to the South African Law Reform Commission Project 141 on medical claims. I'm sure it will be a very interesting webinar. We're going to hear about some of the reforms that may be in the pipeline and some of the ongoing investigations that seek to resolve some of the issues that we are currently facing in the medico-legal sphere, especially with all the litigation and the negative impacts that we face from that. Ronel, I don't know if you're ready. If you are, over to you.
Thank you very much. Thank you for the welcome. Let me do the technical bits. Okay. Can everybody see the presentation?
Perfect. Thank you.
Thank you. Thank you very much for the invitation to once again do a presentation on this forum. I really appreciate it, and I hope that I can add to everybody's knowledge with this presentation. So going straight into the presentation, just in case there are people who does not know who and what the Law Reform Commission is, but I hope by this time everybody is aware of us and what we do. But we are a statutory body. The Law Reform Commission is a statutory body established by Section 2 of the South African Law Reform Commission Act, which is Act 19 of 1973. So we had our 50th birthday last year. And the object of the South African Law Reform Commission is to do research with reference to all branches of the law of South Africa and to study and investigate all such branches of the law in order to make recommendations for the development, improvement, modernization, or reform of the law. I find that people are more familiar with the work that we do than they are with us as a statutory body. So I can just, for interest sake, refer you to some of the legislation that resulted from investigations that we have conducted, such as the POPI Act, very famous, the Children's Act, Trafficking in Persons Act, Protected Disclosures Act. All of those are investigations that we conducted, and some of our new investigations include new marital law, matrimonial property. One that was recent in the news is the repeal of apartheid era legislation. So that's all investigations that we involved with. Now, in terms of today, I'm just looking briefly at three different topics. The one is an investigation that we nearly done with. We're just finalizing the report and the SALRC assessment, which I will explain, tell you just more what exactly the SALRC assessment is. We're just finalizing that, and then we're submitting this project to the Minister for consideration, which I will also explain in our next steps towards the end of the presentation. So this one is almost there to go out. So I cannot really go into detail about what exactly the final recommendations are before it's been submitted to the Minister, but I can give you a sense of the issues that we looked at. So that you just have an idea. And then I will also just refer briefly to the other project, Project 152, which is criminal liability of healthcare professionals, and another possible investigation, and that's a second leg of medico-legal claims to look more at the private sector. So in terms of this one, Project 141 medico-legal claims, which focused on the public healthcare sector, the request for the investigation came from the National Department of Health and the Minister of Justice and Correctional Services. Obviously, it's now changed to the Minister of Justice and Constitutional Development after all the portfolios was, the names of portfolios were changed. And the department and the minister requested the South African Law Reform Commission to include an investigation into medico-legal claims in our research program. And the reasons for this was basically the challenges faced by the public health sector due to the escalation in claims for damages based on medical negligence, the increasing financial implications for the fiscus, and a number of core decisions in medical negligence matters that come out over the past few years. And there's a number of proposals that we considered, which eventually made it into the final report, and where we had to also draft legislation to support these proposals. Some of it cannot really be incorporated into legislation. It's more about policies that has to be implemented, existing legislation that has to be properly implemented, which we found is quite a serious shortcoming. So apart from the legislative proposals, we also made some recommendations that can be implemented without the need for legislation. And a lot of those recommendations centers on improving the quality of care and especially implementing existing solutions and corrective measures. We discovered that even the National Health Act hasn't been fully implemented. Some of the provisions of the National Health Act, which is aimed at supporting proper service delivery in the public healthcare sector, hasn't been fully implemented. I can mention, for example, in terms of the reports, there's a report on the Presidential Health Summit that was held in 2018 that was released in 2019. There's the South African National Lancet Commission, who did a very comprehensive report with some wonderful findings and proposals that hasn't been fully implemented. In fact, reports going back, we found as far back as 2003, which had not been properly implemented. And apart from these reports, even existing legislation, existing regulations, existing guidelines, norms, and standards have not been implemented in full. So that's one of the most important points that we make there, is that there must be proper implementation of existing measures and legislation. Linking to that is one of the important issues is record keeping guidelines. There are provisions on record keeping in the National Health Act itself. There's regulations on that. There are guidelines on that. Yet one of the biggest problems when, especially in cases where sometimes the state cannot defend itself against a medical negligence claim because of a lack of records, or because of the quality of the records that's so poor that they cannot really put up a proper defense. Another one of these guidelines that are in existence but are not properly implemented is patient safety incident reporting and learning guidelines, which includes monitoring and evaluation. There are guidelines on it. Dr. William Oosthuizen is a very knowledgeable person on patient safety because that was his topic for his doctoral research. And I've also looked at his very comprehensive and very well-researched thesis on this. And it's something that's sorely lacking. The whole point of patient safety is, apart from for record purposes, is also the fact that you're supposed to learn from where and how things went wrong and why it went wrong. And if it's not properly implemented, you're never going to be able to correct those mistakes and those failures. Something else that we've looked at is the introduction of an administration compensation system. There were a number of people and institutions that were in favor of a no-fault compensation system, which we said South Africa cannot really afford because a no-fault compensation system means that you will not have to prove negligence. You only have to prove a causal link between what happened and what went wrong. But we did make recommendations on the structure and the functioning of an administrative compensation system so that you can get some systems out of the system much quicker and easier than going through a court process that can take years to finalize. We've also looked at introducing pre-litigation measures as well as civil process changes to limit delays and expedite proceedings. And we also looked at barring a plaintiff from proceeding with a claim after a period of inaction, although it can be extended on good cause shown. This is something that we encountered in the private health sector as well, where a plaintiff will issue summons and then either take no action at all after issuing the summons, or maybe do some work and then also then do nothing further. And that liability, obviously, as a defendant, you have to spend money, spend time, spend effort to try and prepare a defense. You cannot not defend yourself or lodge a plea of defense against this. Otherwise, you will get a default judgment against you. If you can't just ignore it. If you receive a summons, you have to take action on it, and it wastes a lot of time and effort if then the plaintiff doesn't take it forward. Another process that we've introduced is very specifically to provide for negotiation, to make it possible to attempt agreement on certain facts or events before a court hearing, and even to try and settle the matter before it goes to court. The cost and the time is really about, is really spent when the matter goes to trial before court. That's where the very high legal costs originate at that stage. What we've also looked at is a compulsory attempt at mediation before instituting court proceedings to try and also resolve a matter and to achieve a settlement before the matter goes to court. A very important new proposal that we looked at is in order to avoid frivolous, meritless, fraudulent, or abandoned claims, to introduce the requirement for a certificate of confirmation. Now, we initially called it a certificate of merit, and that name was a bit misleading because some of our respondents to discussion paper 154 considered that it meant that there must be an assessment of the merits of a case before you can actually issue summons. But it's really more about making sure that there is a patient that suffers from an actual injury or condition, that it's not just a frivolous case. I'm quite sure would have seen in the media a number of instances. The Special Investigating Unit have now uncovered a number of instances of claims that were fraudulent, where there wasn't even a real claim, and where money was paid out to attorneys on behalf of their plaintiff clients. So to try and see that this doesn't happen, this is a document that has to be lodged. It's in the form of an affidavit. It's in two parts, by the attorney and by a medical practitioner, just to confirm the identity of the injured person. If it's a child, there must be a birth certificate attached, and to confirm through the doctor that what injury this person is suffering from. And the reason why that injury or condition also has to be confirmed, there has been instances where claims has been lodged against the department where it was found that the child actually suffers, it's maybe a claim based on cerebral palsy, and then it was found that the child was really a child born with Down syndrome or some other genetic disorder, and not a child suffering from cerebral palsy at all. Or instances, one of the other things that we consider with the certificate of confirmation is the place where the child was born, the public health facility where the injury occurred or where a child was born, because there were instances of people that hadn't even suffered harm in a public health institution that tried to institute damages. And then in the view of the duties of expert witnesses and the obligation on an expert witness to give objective evidence, we considered saying that parties should use joint expert witnesses and only in exceptional circumstances have additional experts. Also, because of the cost of expert witnesses, it can be, I've seen accounts for expert witnesses that literally run into several hundred thousands of rand sometimes. We've also looked at the possibility of providing for the possible appointment of specialist assessors that would assist a presiding judge in a court case. And another issue was to premise calculation for future losses on a structured format of guideline that will probably be done by means of regulations. Future losses, that would be something like future health treatments, future healthcare. It would also include loss of income, and it would also include future caregiving, you know, the day-to-day caregiving, especially for patients that's severely disabled, that need caregiving, in some instances 24-hour caregiving because they are so disabled. So that all is under future losses. The investigation also looked at introducing structured settlements as the norm for compensation for damages due to medical negligence by state employees. And that would be comprised of a lump sum award only for past expenditure and damages and certain immediate and necessary expenses. And then future healthcare services to be provided in state hospitals as far as possible. That is known as the public healthcare defense in the legal fraternity. And then for other services that cannot be offered by the state, to introduce periodic payments for any other future damages that cannot be provided by means of services. I just want to mention here something that, you know, the government is also able, and the National Department of Health has told me that they have sort of cut their teeth, so to speak, on this aspect during the COVID pandemic, is that government can contract with private hospitals or private healthcare providers to also deliver services on behalf of the state. So the future healthcare services and future caregiving services need not necessarily be only provided by the state, but it can also be procured or purchased by the state. So it's not necessarily that you have to go to a horrible hospital if there are other alternatives that can be provided by the state through a contractual agreement. Okay, so that's just just a brief overview of what Project 141, the public healthcare sector focus part of the investigation, has looked at. And then the other investigation that will start in all seriousness once the Project 141 report has been submitted to the minister. Oh, I said I will tell you about the SALRC assessment. SALRC is an acronym that stands for Socioeconomic Impact Assessment System. There's a desk in the Office of the President that has to consider this, and whenever one wants to introduce a new policy of new legislation, you have to do a very comprehensive questionnaire that has to be considered by the SALRC desk to see if this is legislation that is required, more or less what the impact of legislation would be, who would be affected by the legislation, just to be sure that this is legislation that is necessary, that there are no alternative possibilities to achieve the same objective. So that's also a requirement that all new legislation or regulations have to comply with. Now, in terms of the criminal liability of healthcare practitioners, the request for the investigation originated from a coalition of healthcare bodies and related bodies that requested the South African Law Reform Commission to include an investigation into culpable homicide in a healthcare sector. And they asked us to include that in the Commission's research program. It's specifically with a view to conduct a review on the threshold for criminal charges brought against doctors acting in good faith when delivering the healthcare. I'm quite sure you're all familiar with a number of court cases, high-profile cases that's been in the news over the past few years. There's the matter of Dr. van der Walt, who had to take his case all the way up to the Constitutional Court. In his instance, I'm quite sure you will recall, he was a gynecologist, and a patient in his care passed away. He was found guilty in the magistrate's court, and a sentence of direct imprisonment was imposed. The matter was appealed to the High Court and then to the Supreme Court of Appeal, and in both the High Court and the Supreme Court of Appeal, his finding and sentence were maintained, and eventually it went all the way to the Constitutional Court, and then the Constitutional Court found that because of some errors committed by the magistrate in the first court case, that the matter, he didn't receive a proper hearing. So on that basis, eventually, after quite a number of years, I think it was about 8 years, the matter, his finding was, the finding and the imprisonment was set aside. And then there's obviously also now the murder case against Dr. Peter Beale. There's some more recent cases which I saw in KwaZulu-Natal that's now being brought against doctors. So all of these court cases has created, I think, concerns in the healthcare fraternity, which is part of the reasons why we've been requested to do this investigation. And then what one also has to do, what one also has to look at here is what lessons can we learn from other jurisdictions. For example, charges only brought against doctors if an act is proved to be intentional, reckless, or grossly careless. The reasons that were given for the request was that a long-term solution is needed in terms of the application of criminal law to the healthcare practice. The feeling is that errors of judgment in fast-moving and complex healthcare environments are at risk of being criminalized, and that healthcare professionals, though they do need to be held accountable, one wouldn't want to criminalize inadvertent human error leading to adverse outcomes, because that seems to be unreasonably severe. Criminalization is also felt in the absence of any clear intention to cause harm, is overly punitive, and it leaves healthcare professionals vulnerable to criminal charges. Concerns were also expressed about the degree of negligence required to be proven in the event of a charge of culpable homicide in South Africa. And to expand on that, some of the considerations that we will be looking at here is that the South African criminal law does not provide for degrees of negligence, as in the case, for example, New Zealand, some of the states of the United States of America, the United Kingdom, and Wales. And that one of the possibilities to be considered in this investigation is an amendment of the common law to recognize degrees of negligence in criminal matters, specifically gross negligence, perhaps in the context of culpable homicide charges. I must just caution that it might be problematic to limit this investigation to healthcare professionals only. They're not the only profession that might be exposed to dangerous acts. And if one looks at looking at the comparative legislation of other countries, it is not limited to healthcare professionals. And I can just refer you to some comparative examples. The common law criminal offense of gross negligence manslaughter, which is a common law offense in the United Kingdom. Now, although that offense is mostly applied to criminal prosecutions in healthcare matters, it's not limited to medical negligence prosecutions, because there's no separate offense of medical manslaughter. So if there is another profession where a person is also involved in, possibly dangerous act, they can also be charged in terms of this gross negligence manslaughter. And the difference between gross negligence and ordinary negligence is in terms of proving the crime. Your threshold for proving gross negligence is much higher than the threshold for proving ordinary negligence. Another example is Section 155 of the New Zealand Crimes Act of 1961, and that provides that persons undertaking dangerous acts, and that section specifically refers to acts such as surgical or medical treatment or any other lawful act that may be dangerous to life. So a person undertaking such an act have a duty to use reasonable knowledge, skill, and care, and the unlawful omission of this duty is a crime. I can also refer you to section 150 capital B of the New Zealand Crimes Act, which says a person is criminally responsible if there is a major departure from the standard of care expected of a reasonable person to whom that legal duty applies. In Scotland, for example, there's a distinction between intent, wicked recklessness, and other culpable killings. Scotland apparently is now also reviewing their system. So these are just examples of what one can look at. Obviously, when we start with the proper investigation, we will look at additional international examples. And then the third topic that I want to refer you to is medico-legal claims in the private healthcare sector. As I said in the original investigation, the original Project 141 investigation, the medico-legal claims investigation, the focus there was on the public health sector. But in the comments that we received from stakeholders on issue paper 33 and discussion paper 154, which were the two papers that we published during the course of that investigation as part of our public consultation process. So the comments that we received from stakeholders on those two papers, a number of stakeholders expressed quite strong support for expanding Project 141, like I said, which focused on the public health sector, and they said it should really be expanded to the private health sector. The reasons given by stakeholders was especially the increase in the cost of indemnity insurance for medical malpractice, the increase in the size of excess payments, the costs and stress caused by complaints and litigation to medical practitioners, the knock-on effect of medical practitioners leaving high-risk specialities or choosing not to specialize in high-risk practice areas. And here one can think of the two areas with the highest risk, obviously, is gynecology and, well, especially obstetricians, and then spinal surgeons and neurosurgeons. And then the other problem that is caused by private health sector claims is the practicing of defensive medicine, where medical practitioners start doing unnecessary tests just because they're scared of a possible negligence claim against them if they do not do all those tests. Obviously, that increases the cost of private health care, and I think that's part of the reason why the private health sector is often told by the public health sector that they over-service patients in the private health sector. Now, some of the issues that were raised in comments that we received is, for example, from clinics that says that the situation regarding claims in the private healthcare industry is as critical as it is in the government sector. Ethical, that said increasingly high common law damages awards handed down by the courts will cripple both the public as well as the private health sector. The Gynecology Management Group that says South Africa is moving towards greater integration between the public and private sectors, and then that makes it vital to ensure that there's consistent liability and ensure that a consistent liability and insurance sector based on the risk that span both sectors. Life Healthcare mentioned that the amendment of the Road Accident Fund Act, coupled with increased patient awareness of constitutional and consumer rights, has led to an increase in medico-legal litigation against the state as well as against the private healthcare sector. Mediclinic said that the private healthcare sector constitutes an essential component of healthcare provision in South Africa, and that medical legal claims have increased due to a rise in patient awareness and legal practitioners marketing their services, actively seeking out, oh, I'm so sorry, I see there's a typo. It's not seeing out possible claims, it's seeking out possible claims, and their willingness to act on contingency. This is something that's very prevalent in the public health sector. There's anecdotal stories of agents for legal practitioners that go to public health facilities especially where cerebral palsy children are receiving treatment, and they then solicit business by talking to the guardians or the parents of disabled children to see if they can get people to institute claims against the state. And you will all have heard this no win, no fee advertisements that one sometimes hear on the radio, which is taking a claim on the basis of contingency, that if the client loses the case, then it's said that they will not have to pay the legal, their own legal practitioner's fee. What obviously they failed to mention is that if you lose a case, you're still liable for the legal costs of the winner. If the defendant wins the case, you're still liable for those costs. But obviously the attorneys don't mention that in their advertisements. The South African Private Practitioners Forum mentioned the cost of malpractice cases, irrespective of whether it makes it to litigation, and in particular, if it leads to the payment of compensation, and that cost obviously is significant to both the private and public sectors. Like I said earlier, when I referred to the certificate of confirmation, the whole idea is with a certificate of confirmation is that you will weed out people that have frivolous claims. People are just trying to take a chance to see if they can get something out of the system, and to weed out the fraudulent claims, because it costs money to defend a matter. Even if that matter doesn't come near a court, it still costs the money, because you have to brief a legal somebody has to look at that claim, consider whether it has merit. You have to brief a legal practitioner. You might have to consult a specialist expert or an expert to see if there's any merit to the claim. So even if it doesn't proceed, it does cost you money. And obviously, as long as that summons is on your books, it's a contingent liability in terms of your institution or in terms of your own practice. The South African Spinal Society mentioned that the increase in the number of high quantum claims against spinal surgeons in South Africa has resulted in a drain of resources in the public sector, as well as a significant increase in indemnity insurance subscription rates for private sector spinal surgeon, and that this may eventually lead to a shortage of spinal surgeons due to their inability to afford insurance premiums in the end. There were quite a lot of criticism aimed at the Law Reform Commission for not also looking at the private sector when we did the Project 141 investigation, and we were requested to expand it. But at that time, it wasn't possible. The main reason was that the investigation was requested by the Department of Health and the Minister of Justice and Constitutional Development, and it was principally because of the impact of medical legal claims on the fiscus. It's getting so severe that service delivery in the provinces is under serious threats, especially in the rural provinces like the Eastern Cape, Limpopo, KwaZulu-Natal, that they're getting to a stage where so much of their budget is taken up by medical legal claims that they've had to compromise on service delivery. And another factor to consider is that an investigation into medical legal claims in the private health sector would require a different approach than the approach followed with the investigation into medical legal claims against the state. Another concern was that measures to address medical legal claims in the private health sector and measures to address medical legal claims in the public health sector would not fit comfortably in the same piece of legislation. And I'll elaborate more on that. One of the big reasons here is that the basis for liability in the private health sector is the law of contract, and that's in the domain of public law. A patient and a medical practitioner enter into a contract, actually, even though it's not necessarily all on paper. An oral contract is just as binding as or a verbal contract is just as binding as a contract written down on paper. It might sometimes just be more difficult to prove, but that's really the reason for the relationship between a doctor and a patient. On the other hand, the basis for liability in the public health sector is the constitutional right of access to healthcare services, and that's in the domain of public law. So one of the main concerns in the private health sector is the high cost of indemnity insurance for medical practitioners. And you will also recall that the National Health Act actually contains a provision that makes it compulsory for private health sector practitioners and institutions to have indemnity insurance. But for the state, this is not necessary, and the reason for that is Regulation 12.1.1 of the National Treasury Regulations of 2005, which states that the state bears its own damages and accident risks and is responsible for all claims that arise from state activities by an official who is liable in law and who is or was employed by a state institution. And this is the reason why the state doesn't take out insurance, because the state is responsible for carrying their own risk. Now, possible avenues of research that we're looking at in terms of an investigation into the private health sector. There was mention made of the possibility of employing healthcare practitioners in the private sector, employing them by hospitals and hospital groups, which you are well aware that medical practitioners, although nurses and the persons falling under the allied health professions like occupational therapists, physiotherapists, speech therapists, etc., although these practitioners can be employed by hospitals and hospital groups, medical health practitioners cannot be employed as medical health practitioners, and that's something that one could look into. Internationally, there are a lot of examples of private hospitals and hospital groups having medical health practitioners in their employment. One can also look at multidisciplinary practices, and the reason why these two bullet points are important is that it will spread the risk and it will make cheaper for a group of people or for a whole hospital group to get insurance, as opposed to an individual being responsible for their own insurance. There's also mention made that one needs to review the regulatory measures pertaining to the indemnity insurance industry and the role players in that industry. There's the issue of informed consent, and that's important because if a patient is properly informed of the risks of a medical procedure or of a particular treatment or of surgery that they will have to undergo, the chances of them afterwards then instituting a claim because of something that because of an adverse event is definitely smaller. It's also important to management patients' expectations. I think people are blindsided by what Hollywood pumps out in terms of people, that's nearly dead and then that recovers miraculously, which we all know in real life is not the case. So it's also important to be realistic so that patients are aware realistically of the chances of success of the treatment. It's quite important to have proper patient complaint systems in place. It's been proven that people would sometimes institute claims, not so much because they want compensation, but because they dissatisfied or they didn't get a proper explanation or they just want to receive an apology. So if one has a proper patient complaint system, that system will help to address these kinds of concerns without necessarily leading to litigation. Alternative dispute resolution, which includes arbitration and mediation, is quite an important factor, and it's playing an increasingly important role in modern society. I'm quite sure you may have heard that the court role in the Pretoria High Court is now, I think the first available date now for cases is 2029. The court role is so full, and a lot of it is road accident fund cases. And there's quite a concerted effort by government to promote alternative dispute resolution. And one of the main reasons for that is to try and clear the court, keep matters out of court, and to try and clear the backlogs in the courts. Pre-litigation processes, I've referred to one of the considerations in the state-focused medico-legal claims investigation is to look at pre-litigation processes, to look at how that can be expanded, specifically with the aim of keeping matters out of court and trying to see if one can resolve a dispute before going to court. And if you cannot resolve the entire dispute, to try and resolve as much aspects of the dispute as you possibly can, so that you cut down on the court time if you do go to trial. And something else that one can look at is possible procedural amendments that one can bring into the, once litigation is started, there's quite a raft of court rules that apply to how this case is brought. And because these are usually high value claims, they almost always go to the High Court, because the size of the claim puts it beyond the jurisdiction of the magistrates' courts. So these matters go to the High Court. And if one can try and see if you can expedite certain procedures, that will also, cut down on the time and the costs. There are some procedural provisions in the Court Rules Act. The problem is many of those provisions are voluntary. They're not compulsory. So one could look at seeing if one can strengthen some of these procedural requirements to try and get matters to move forward faster. Obviously, one can also look at alternative compensation methods, like we've done in the public health sector part of the investigation, to see if there are other ways than just these normal lump sum payments that one can try and deal with, introduce to deal with claims. And then in terms of the next steps, and I see I have about 4 minutes before the question and answer time. I just want to be realistic in terms of what people can expect from the Law Reform Commission reports. We are the Law Reform Commission is an advisory body. We do not have any executive powers, and our reports are in the nature of recommendations. So the Section 7 of the Law Reform Commission Act determines that the Commission must prepare a full report on a matter investigated by it, and that report then must be submitted to the Minister of Justice and Constitutional Development for consideration. And obviously, if we also prepare draft legislation, that must be included in the report. The reason why it goes to the Minister of Justice and Constitutional Development, although the Minister cannot instruct the Commission to do certain things, the Commission is, the members of the Commission is appointed by the President, so it's quite high-level people. But politically, we resort under the Minister of Justice and Constitutional Development. So we have to submit our reports to the Minister for consideration, and the Minister also has to give us the green light before we can release the report for public notice. If the legislation falls within the purview of a state department other than the Department of Justice and Constitutional Development, then the Minister will refer the report and the draft legislation to the appropriate state department, which will definitely be the case in the medico-legal claims investigation, the part of it that affects the Department of Health. Obviously, that relevant legislation will have to go to the Department of Health, and they will then have to take it further. And like I said, we're an advisory body. We make recommendations. It still remains the prerogative of the relevant minister to decide to table the proposed legislation in Parliament for adoption. And then just to conclude, here is my information. I'm happy to, if people would like to send me messages or have specific inquiries, I'm always willing and open to give people information. Since I work for government, I cannot give people legal advice, but I can give people information that might help them. So thank you very much for giving me this opportunity. And if there are any questions, I'm happy to help as far as I can. Thank you.
No, thanks so much, Ronel. A wonderful, informative talk. I think all of us have learned quite a lot about how the sausage gets made and the important work that you do behind the scenes. So just thank you so much for taking your time and sharing this information with us and the updates on where these vital projects currently are. There are a couple of questions in the chat. The first one is, Ronel, could you please elaborate on administrative compensation systems? Does that include capping of compensation? Ronel, are you still there?
I'm here. I was making notes. I thought you don't want to look at my face all the time while people are asking questions.
Is it fine with you if we do?
Do you want me to deal with each question individually, or do people want to sort of pose a round of questions? And because I was making a note of this one, or was this the only question? Are there
No,
other
there are a
questions?
couple more. Let me give you the next one,
Okay,
then we do two
let
at
me
a
do
time,
a round of
perhaps.
questions, and then you
Sure.
can decide how many you want to give me, and then I can I think it will be maybe more time effective if I take a round and then deal with all of them rather than doing them one by one.
Certainly.
Okay,
And
thanks.
the next question then is, under the NHI, would healthcare practitioners be fully indemnified by the state? So that's an interesting one, and having you look into your crystal ball into the future, perhaps. And then there's another question here on Dr. Donnie van der Walt's case that was overturned due to some procedural difficulties at the magistrate level. And are there then any repercussions for some of these procedural errors that magistrates or judges may find themselves making? Let's take those three first, and then I'll look for the next round of questions.
Okay. Okay, in terms of the administrative compensation system, that will require government to create basically a statutory body, so that you can, what we're trying to do is to give people the option is that they can go for the administrative compensation system, which doesn't preclude them to go to litigate a matter if they want to, but we're hoping with that the advantage of the administrative compensation system, because it will be much simpler and much quicker, so that they will opt for this rather than going for litigation, because litigation is really where the cost. I saw a bill of costs in a particular matter, which where the legal costs amounted, the legal costs and all the disbursements, the costs and the payments of the advocates, the payment of counsel. Advocates and counsel are the same thing. The payments of experts, sorry, that's what I wanted to say. The legal costs in that matter amounted to 19 million. Which makes no sense whatsoever. So the administration compensation system wants to create an alternative where you can go for a much quicker and easier system. In terms of the compensation, you will the slide that refers to structured settlements. One of the components of a structured settlement would be prescribed. What we're envisaging is sort of prescribed compensation for future losses, so that there can be maybe a set of regulations or some guidelines that gives guidance in terms of what will be covered under future compensation, so that you don't have this open-ended amounts that end up going into, towards 20 or 30 million. So that it's not so much that you're capping the claim. It's more that you structure the claim and provide guidance. I've spoken to provinces, a province like the Western Cape that have good records. They say that based on the injury or the condition that a person suffers from, that an injured person suffers from, you can basically predict what kind of treatment, rehabilitation, healthcare services, assistive devices, etc., that person would require, because you have your records going back, you have statistics, you have also help, guidelines within the legal space, where you have something like Koch's quantum handbook. So it is possible to sort of come up with a system to have a more definite sense of what the compensation people would require, so that you don't have court cases running into months and countless court hours, for example, to take a decision on quantum, because that's really where your legal cost eventually eat up all the award that was made for quantum. So that's the idea. It's not so much capping of claims, but rather a guideline or a structure on how much claims would be awarded for particular injuries or conditions. In terms of the National Health Insurance Act, the indemnity for public in government is for people employed by the state. So if you're employed by the state as a medical practitioner working at a public health facility, you will be indemnified in that sense. So if no negligent conduct committed by a health practitioner in the employment of a province, because that's where the most doctors that actually provide medical healthcare services, that's where they are employed. So if their negligent conduct then leads to an adverse event that causes damages, that causes harm to a person, the state will be liable to pay for that. But there is a requirement in the Public Health Act that if the state suffered harm because of the action of an employee of the state can also actually institute civil proceedings against the person who caused the damages to the state, to try and recover the costs from that person. So it's not going to be a magic wand where the state now becomes liable and can indemnify everybody. And from what I understand under the NHI, and I'm not an expert on the NHI, I've read it and I've looked at it, but I've not studied the detail of it. But if the state contract somebody or procure services through somebody, that person is considered to be an independent service provider. And normally, if you, the principal that pays somebody to deliver a service for you, you are not responsible for the harm or the damages that they cause. So it's a normal contractual arrangement. So it's in terms of how what the state covers, it's normally for government employees, for people that's employed in terms of the Public Service Act, that would be covered. The other one, in terms of the procedural issues in the Magistrates Court in Dr. van der Wald's case, apparently what happened, the magistrate in that matter didn't only rely on the evidence provided by the expert witnesses. The magistrate also did her own research. And part of the finding that was made in that case was based on the magistrate's own research, and that's irregular. The court cannot they cannot sort of overrule. I want to say, yes, an expert is there to assist the court to come to a decision, but the court is not an expert in every field, and that's why you call experts in the first case. And that's the reason why the matter was overturned eventually, because the justices in the Constitutional Court was of the view that Dr. van der Walt did not receive a fair trial because of that. However, the Van der Walt case was not just discharged on the basis of the merits of the case. So actually, that case can be reinstituted against Dr. Van der Walt because the dismissal was on technical grounds and not on the merits. So, but there hasn't been so far any attempt on the side of the National Prosecuting Authority to reinstitute the prosecution. So realistically speaking, I do not think it will happen. Thank you.
Oh, perfect. Thanks so much, Ronel. Maybe another quick round of questions before we close. So the question from Dr. Chetty is, at present, who decides to criminally charge a doctor? And do you feel that the inquest process is being respected as described by the Act? And the next question to maybe touch on, somebody just asking that we flag your contact details again. We'll also share that with the attendees. And then the next question is, Ronel, what in your opinion is the likelihood of us acquiring specific medical courts to deal with these highly technical issues?
Okay.
And I think those are the two final questions that we've got time for.
Okay. In terms of criminal prosecutions, it's the National Prosecuting Authority that decides whether to charge somebody criminally or not. The police, obviously, once a charge is laid, the police must do the investigation. So the quality of the police investigation obviously plays a role here. And the National Prosecuting Authority, and obviously delegated officials, because the National Director of Public Prosecutions cannot take all these decisions on her own. It's delegated, but they basically decide on the basis of the evidence that they have available whether they think they will be able to get a successful prosecution in that matter. The inquest is actually a separate process. It's not compulsory at this stage for an inquest to be completed before the NPA decide to institute criminal prosecutions. If there had been an institute, they can probably use some of the evidence or information uncovered by the inquest, but they basically decided on the basis of the information that they have available, which would mostly be the police investigation and then information uncovered by an inquest if an inquest had been done. I cannot tell you whether an inquest was done in the case of Dr. van der Walt's matter. And I also don't think a formal inquest was done in the case of Dr. Peter Beale's matters. I do know that the Health Professions Council did do an investigation in the case of Dr. Peter Beale, and that some of those evidence were presented during the criminal hearing so far. Then, in terms of the likelihood of a medical court, I had a lot of discussions. I know that there were quite a number of people that were very much in favor of creating a specialized court. We do have specialized courts, like we have tax courts, and we have the land claims court, and we have the courts that can hear hate crimes and discrimination and that sort of thing. In a lot of these instances, it's the existing high court structures that's just used for a particular purpose. An important consideration is that there are not really enough medico-legal matters to justify a specialized medical court. And the specialized courts that I've referred to, the tax court and so on, they are civil courts. There are some specialized specialization in terms of criminal court cases. But if you look at the number of medical negligence well, not medical negligence, culpable homicide and murder cases that based on the conduct of medical practitioners. There's not enough cases to justify a specialized court. So the compromise sort of was to say, then maybe provide for assessors that can assist a judge with highly technical matters or evidence of a highly technical nature, so that you don't incur the cost of creating a specialized court where you don't really have enough cases to justify that. I have been referred to the example of the Gauteng division of the High Court that created a commercial crimes court. In terms of the Superior Courts Act of 2010, there's a provision that courts can issue directives for that division of the court. So there was a directive issued to create sort of a commercial crimes court for that division, but there are actually some people that said, it's not really that directive, being able to issue directives about the proceedings of a court and the procedural matters doesn't really allow you to create a whole additional court, for a particular kind of crime. But it hasn't been challenged so far to my knowledge, and so far as I know, it's only in the Gauteng division of the High Court. But really, specialized medical courts, the cost attached to it and taking scarce judges out of the system to only hear medical matters, we don't have enough matters to justify that. Thank you.
Thanks so much, Ronel, and also just in the nick of time, I'd like to just thank you again for the wonderful presentation and sharing your knowledge and answering some of the questions. Those questions that we didn't get to, I think we'll collect all of them and just get back to the people that asked them to answer them, or maybe put together a frequently asked questions part on our website. Everybody that's joined the webinar, thanks so much for joining us. As mentioned, this has been the third in our series of medical law webinars. I hope you're enjoying them and getting value from them. I do see a number of familiar names, so a few of you have joined many of these, and I'm glad to see that. Just thanks again for the Health Policy Law and Ethics Committee, Prof. Dai and Dr. Mzukwa, our chairperson. And thank you, everyone. Ronel, thanks again. Have a lovely evening and enjoy the rest of your week.
Thank you so much, and you're welcome. Thank you.